I'll turn quickly. I just wanted to say something about payment because I'm really seeing a lot of movement in this area. I mean, the private payers, like Medicare, are continuing to adopt value-based payment mechanisms. And I'm seeing this increasingly funded by medical loss ratio savings and then paid out based on quality. So say the plan's medical loss ratio point is 85%. Under 85%, they have to start sending checks to members. What they'll do is they'll set up a risk pool. And if the MLR looks like it's coming in at 82%, that 3% goes in a risk pool to be paid out to physicians based on quality and meeting quality goals. It might not get paid out to all physicians, but as long as it's paid out to physicians, it counts as being paid, and you're still at the 85% MLR. Checks go to the physicians instead of the members.
What is the definition of quality?
It depends on the health plan. I see in the Medicare Advantage world, they'll tie them to star ratings a lot. It just depends, and it'll be different for different types of physicians and for every plan. There's no individual standard. So I thought it was interesting. In 2011, 46% of payment arrangements had a value-based feature. By next year, that's going to be 75% of payment arrangements are going to have some kind of value-based feature. Another thing that I'm seeing is Medicare Advantage plans contracting with the ACOs. And I put parentheses around this because they're not really formally Medicare ACOs because their members can't be in Medicare Advantage plans, but they're set up the same way, and the Medicare Advantage plan is letting the ACO really do the care management and take the payment risk. So speaking of Medicare Advantage, and I know that's some of your favorite topics, an issue we saw recently come up was Part D and coverage of drugs dispensed in office. And I don't think it was on anybody's radar. It certainly wasn't mine, but the regulations actually say that physicians' offices are out of network for purposes of Part D coverage, which was, I think, it was a surprise to some of the big PBMs. It was a surprise to a lot of the plans, and certainly physicians who were doing in-office dispensing. And this just came up about a month ago. One of the big PBMs started terminating all the physicians in its network. And I got calls from the plans who actually liked for drugs to be dispensed in office and asked me about this, and CMS was supporting the PBM and its move. It's interesting because the Part D regulations say that Part D plans have to cover drugs and vaccines dispensed out of network when an enrollee can't reasonably be expected to obtain such drugs at a network pharmacy. They require the plans to have some type of arrangement to make sure that they are covered, but they're not allowed to access them on a routine basis or to get more than a 30-day supply. Interestingly, just in the last 2 days, I got feedback that there was a huge uproar about this, particularly in the context of oncology offices. And some of the oncology offices had their own pharmacists employed. And CMS backed off and Caremark backed off, at least with regard to oncology. So we will see if they back off any further, but I know this issue is under consideration. Right now, the regulations are pretty clear, so it might take a regulatory change, but there has been some plan blowback and certainly some physician blowback about this policy that hadn't been enforced before, but's been in the regulations since the beginning of the Part D program. There's a new Medicare Advantage demonstration, and it's going to start at the beginning of next year. And it's actually an interesting demonstration that could offer opportunities for podiatrists. Under Medicare Advantage, there's a requirement called the Uniformity of Benefits Rule. And it basically says all members have to get the same benefits for the same cost and coinsurance. That seems self-evident, but it also doesn't play well. So I get calls from plans sometimes, and they have low-income members, and their members won't see the doctor. They've used up, the plan might offer a transportation benefit. They've used up all the transportation benefit, and the plan wants to give them extra transportation because it's cheaper to keep that person well and make sure they see the doctor. And I have to say, no, that violates the uniformity of benefits rule. And I've been in ALJ hearings where I've had members say, it's cheaper if you let me do this. And it is, but the plan can't do it because of the uniformity of benefits rule. This demonstration allows them to get around that. So they can do varied benefit design for a subset of enrollees, those with certain chronic conditions, including diabetes. They can reduce cost sharing for certain services. They can offer additional services to targeted enrollees. They can identify high-value services based on that person's chronic disease, or high-value providers. So, for example, they could actually have lower cost sharing for diabetic members to see podiatrists than to see MDs if they wanted to, if they recognize that they had an interest in doing that, and that would keep their beneficiaries more healthy. So it starts January 1st. There were 7 states that were named that were available. It turned out that the plans in only 3 of these states were interested. There'll be one of them in Indiana. Pennsylvania is a big place for these demonstrations. There are 7 plans participating in Pennsylvania, and 3 plans participating in Massachusetts. They're adding to the available states, and right now is the application cycle for 2018. They're adding Alabama, Michigan, and Texas. So there are now 10 states where plans could potentially apply, and that's just something to look out for and pay attention to. So with regard to non-discrimination, this is the ACA provider non-discrimination provision, and we haven't seen much movement on a regulatory basis. We see states adopting laws to implement the federal provision, but they tend to have the exact same language that doesn't really include a lot of information in it. But we now have 3 lawsuits going regarding what that means and what the scope of it is. 2 of them are more relevant to APMA, but I wanted to talk about all 3 of them. One of them is right in Virginia. It involves a 3-physician practice that provides biopsy diagnostic services. Anthem started out on January 1 cutting their rate by 18%, and then came back in October and said, we're going to cut your rate for your lab services 60% more. The physicians were in an uproar. They started negotiating with Anthem. They came out with some kind of agreement that they signed, but they also told Anthem, we're signing this, but we're going to sue you. So they brought Section 2706 anti-discrimination claim as part of their whole package. They had several claims, but they brought it as a breach of contract claim because the provider contract said that Anthem agreed to comply with all applicable laws. And they did this because early on, both Anthem, the physicians, and the court all agreed that there was no private right of action under the non-discrimination provision for physicians. So they fought about venue. It's in state court now. They decided there was no significant question of federal law, this court did. The court has upheld the physicians on the motions to dismiss, so it's moving forward, but they did tell Anthem that they could terminate their contract with the physicians. Nothing would prohibit them from doing that. So we'll see where that goes. Another case is against HCSC, which is, if you don't know what that is, that's the Blues plan that owns Illinois, Montana, New Mexico, Texas, and maybe others. So it's a big Blues plan, exactly. And this claim, they're claiming that their HCSC's failure to provide coverage for residential treatment of mental illness It only covers outpatient mental illness, violates a bunch of ERISA obligations, including 2706. HCSC is basically saying, 2706 only protects services that are both covered and medically necessary. It doesn't mandate coverage of any particular services, only not discriminating against providers based on the scope of their licensure. So the court basically said, this case is going forward. Neither one of you has provided me enough information to understand what this provision means. It's clearly not as easy as each of you claims, so we'll see that moving forward. The most relevant case, however, and I've spoken about this before, is being funded and put through by the Oregon Association of Naturopathic Physicians. They are not a party to the case. The parties have been members of Health Net and some naturopathic physicians. So in their complaint, they were looking to establish a class action comprised of all the enrollees and these physicians. I think the practices that they're citing as violating 2706 will look pretty familiar. They have an annual limit on the number of reimbursable visits to a naturopathic physician. They require a medical necessity review that isn't required for other types of physicians. They put a cap on the benefit for naturopathic medical services. They put a limitation on the services that they can provide that is more narrow than their scope of practice under the law. And they reimburse them 80% less than other physicians for providing the exact same services. So they're seeking several remedies. They want to see reimbursement to individuals, members of the health plan, that were denied benefits. They want to see a repayment of profits retained by Health Net as a result of their practices. They're alleging that Health Net is profiting by these non-discriminatory practices. They want to see enforcement of the non-discrimination law in the future, and they want to have a court order for Health Net and their provider network that clarifies which of their practices are unlawfully discriminatory. So, of course, Health Net filed a motion to dismiss, which is always to be expected. That was initially partially granted, but the judge dismissed the complaint without prejudice and told the association to file an amended complaint, which they did. The only claim dismissed on the amended complaint was the third claim, and that was the physician's claim. They said that only patients harmed can seek redress under ERISA, not the physicians. So they're moving forward with discovery on the other two claims, and this lawsuit's ongoing. This is the one to watch. I think this one will be the most relevant to APMA. It's the same types of discrimination that podiatric physicians see, and we're keeping an eye on this. And that's it. I wanted to leave time for questions. How am I doing? Time? Any? Yeah?
How does that last case reflect with dietary? How would you equate
Well,
where we stand and where that case is?
I think it's very similar, just because some of the practices, the lower reimbursement rate, caps on benefits, these are types of things. And there are certain states that have said, like Colorado, for example, in a Q&A from the Office of Inspector General has said, like, caps on services provided by, for example, I think in that case it was chiropractors, violate the non-discrimination clause. I think these are some pretty egregious practices that it would be nice to see the court come out and say, those are clear violations. We have no precedent in this area yet. We have regulators that aren't ready to move forward and interpret it. So having the courts do this is a slow process, but it'll be helpful. Yes?
Kelli, we have something going on in New Jersey that we haven't seen before. Our biggest insurer in the state, Verizon, we have quite a litigious relationship with, unfortunately. we have had a new product introduced in the state called Omnia. And Omnia has tiered hospitals, and they have tiered providers. And those that are tier 1, they provide a product, that there are no co-pays. And they are less than forthcoming about how they tier physicians. We know that the tier 2 hospitals have tremendous co-pays, mostly Catholic hospitals in the state. The teaching hospitals have been tiered tier 1. So they're steering the patients, and most of these patients are state healthcare employees, state employees that provide healthcare at low cost. Is there anything that we can do to make them a little more forthcoming on what they consider the criteria for tiering? They have not been forthcoming. I'll give you an example. I have been in practice for 30-something years in a very small provider. We have academic credentials at a teaching hospital. I would tier it as tier 1. Residents that I've trained with superior training, 3-year surgical residencies, great qualifications, board certified, have been tiered tier 2. They have no appeal rights. They don't tell them how they're scored. As a matter of fact, we had one physician in the state who was tiered tier 1 last year, and then was told that he was scored less this year, and he's now tier 2. His partner is still tier 1. But how can we make them be a little more forthcoming on how they decide what their quality is, their scoring methodology?
There were a bunch of law schools or lawsuits in New York over this. The New York Attorney General went after plans for tiering and entered into settlement agreements requiring some openness about it to members, because they were saying, you know, members think you're tiered based on quality, but in fact it's utilization, and you can't lie to members like that. They also required appeal rights, and they required NCQA review of the tiering patterns. And some of those payers adopted that nationwide for their own practices, and some quality organizations also adopted that as a standard. I did a big article on this for APMA. In response to your question, there are a lot of models out there, but if your state regulators aren't ready to go after this, it really is a consumer issue, which is great, because that tends to be what state regulators get excited about is, you know, are they misleading consumers? Do consumers believe that this is based on quality when actually 40% of the measure is utilization? And we're just saying these are the cheapest providers, or it's the cost of their contract or other issue.
The state actually entered within the lawsuit to support the Catholic hospitals, because they, in our southern part of the state, they felt that there was sufficient access to these hospitals, and they got absolutely, the court decided they're not going to volunteer it.
Oh, really?
So basically, they were given carte blanche to do what they want to do, and I'm concerned that our little experiment in New Jersey is going to spread to other cities.
Well, it actually has. I mean, it's everywhere. Massachusetts requires by law that plans offer at least one-tier product. There is a famous lawsuit in Washington State involving Boeing and their employers and their tiering, which, you know, the court overturned because people didn't have access to the members that they wanted. I'll make sure you get that article and you can take a look, but it really is a widespread practice now, and there should be, there's a lot out there written about it, and I'm sorry to hear that New Jersey is so backwards on this, because a lot of state regulators have become involved. They've required transparency, they've required an appeal right, and particularly for consumers to know, like, are you just making me go to the cheapest provider? You know, or are you making me go to the highest quality provider? Yes.
So tiering is illegal? Is it state by state, or is it federal, or it's?
It's not illegal anywhere.
Okay.
It's a matter of whether states regulate it. In some places, it's required by law. Like I said, in Massachusetts, every plan has to offer at least one tiered option. And interestingly, they don't say what you have to tier based on. It could be tier or who you have to tier. Some plans just decide to tier hospitals based on costs. Other plans tier all their providers. There's no regulation of what you tier. You just have to offer one tiered plan.
I'm also assuming that insurers can lower reimbursement for specific providers as long as they give you notice in the amendments?
Yeah, exactly. It depends on what your contract says.
Well, I mean, just like I have a group, and for United, we had 20% above Medicare rates. 3 years later, it was 20% below. So we renegotiated the best we could get was Medicare rates. So when it comes to terminating that contract later on, which, I may convince my doctors to do that, because why not just take Medicare and not have to worry about deductibles and copays and all this other stuff, and just take Medicare? So instead of terminating the contract, can we just say, when the patient calls as United, say, well, we're not going to see you today? Or does that mean, depends on the contract, I guess what it says.
Exactly.
But, so there's ways around that too, I would think, but.
Yeah, it depends on what your contract says. Usually they'll say you agree to see our members on the same basis that you see any member. And so contracts generally prohibit you